Hello, you're watching Addleshaw Goddard's Employment Channel on the 9th of August 2012. In today's news programme, our headlines include an interesting case from the Employment Appeal Tribunal on service provision changes under the Transfer of Undertakings Protection of Employment Regulations 2006, or 2P for short. We also look at a Court of Appeal decision on sickness and annual leave. In other news, we look at proposals to introduce fees in employment tribunals and some guidance issued by ACAS to help employers manage redundancy for pregnant employees or those on maternity leave. Finally, a recent landmark ruling for race victimisation against a football club. This is believed to be the first case of its kind in British legal history. So first up today then is the case of Tourist and Crofts, which looks at whether there is a service provision change under 2P when there's also a change in the underlying client. Well, this is quite an important case on how to interpret the wording of 2P in relation to service provision changes. As a quick reminder, 2P operates to protect employees' rights where there's been a relevant transfer. This can be either a business transfer or a service provision change. Service provision changes can occur in three situations: either where a client contracts a service out, where a contract is reassigned from one contractor to another, or where a service is contracted back in-house to the original client. So this case then related to the second situation there, where a contract was reassigned from one contractor to another. So the facts of this case then: Mr. Croft was employed as a security guard by a company called Reliance. Reliance provided security services to the owner of some student accommodation, so Mr. Croft was posted there to work. However, when the accommodation was later sold, the new owner decided to appoint a new company, Taurus, to provide security services instead of Reliance. As can so often be the case, Mr. Crofts ended up falling between two stools really, as Reliance refused to give him any more work or to make him redundant because they said his employment had transferred to Taurus. But Taurus refused to offer Mr. Croft a job because they didn't accept that his employment had transferred to them. Unsurprisingly perhaps, Mr. Croft was left with no option. He claimed unfair dismissal against both Reliance and Taurus. So what did the courts make of all this then? Had there been a service provision change here, and so did 2P apply or not? Well, the relevant wording in 2P states that 2P will apply where activities cease to be carried out by a contractor on a client's behalf and are reassigned to another person, a subsequent contractor, to carry out on the client's behalf. So the tribunal held that 2P had applied to transfer Mr. Croft's employment from Reliance to Taurus because where the legislation refers to activities being carried out on a client's behalf, the word client means whoever requires those relevant services from time to time. Here then, that would mean whoever owned the student accommodation from time to time. Therefore, a service provision change had occurred under 2P and liability for Mr. Croft's unfair dismissal claim had transferred to Taurus. However, this all changed when Taurus appealed to the EAT. The EAT took a completely different view to the tribunal, holding that there hadn't been a service provision change under 2P in these circumstances because the underlying client had changed. In the EAT's view, the reference in the legislation to the words "the client" referred back to a specific client. So here, because ownership of the accommodation had changed hands, the specific client was different and 2P couldn't apply. Quite a tricky area, I thought, so I thought I'd ask Kate McGough, a managing associate in Addleshaw Goddard's employment group, her take on what this decision means for employers. Hi Kate, this seems like quite an important case then on the exact wording in 2P. Has this issue never cropped up before?
It has actually, Helen. There was a case at the end of last year called Hunter and McCarrick, which was also heard in the EAT and featured on the Employment Channel in March. That and this new case are both significant for outsourcing transactions, and particularly in relation to commercial property.
So when you say significant, how is that exactly?
Well, it's relevant where the ownership or management of a commercial property changes at the same time as a change in facilities provider. So where this happens, facilities staff such as cleaners or security staff may not now transfer to the incoming facilities provider. And this is relevant because that means redundancy costs and other employment costs could now stay with the outgoing facilities provider. And it's pretty important then that facilities providers think about this risk when they put their contracts together.
Yeah. Overall then, I suppose that could be pretty good news for incoming service providers, is that right?
Well, potentially yes. So there's two notes of caution. The first is that the Hunter and McCarrick case I mentioned is being appealed and is due to be heard by the Court of Appeal in October this year, so the position could change. And secondly, it's worth remembering that contractors, outgoing contractors and employees could still try to argue that there is a business transfer, so using the definition you mentioned earlier. And all you need to do in order to argue that is to show that there's an economic entity that's transferred and retained its identity.
Well, that's very helpful, Kate. I suppose just to wrap this up then, is there anything else that employers need to be aware of in this area?
Well, it's worth remembering that the government has put out a call for evidence in relation to TUPE and in particular service provision changes. We're still waiting to hear, but if service provision change provisions are taken out altogether, then all outsourcing transactions will need to have a look at whether they still fall within the business transfer definition.
Very interesting. Thanks very much, Kate. One to watch, I think. Next up then is the case of NHS Leeds and Lana, fresh from the Court of Appeal. This case is another pretty important decision because it's on the tricky subject of employees' entitlement to annual leave whilst on sick leave. Mrs. Lana worked for the NHS, went on paid sick leave in January 2009 and didn't return to work before being dismissed in April 2010. She didn't ask to take annual leave while she was off sick during the 2009 to 2010 leave year, and she didn't ask to carry it forward to the next leave year either. However, she went on to claim that both the Working Time Regulations 1998 and the European Working Time Directive entitled her to be paid in lieu for this untaken annual leave when her employment terminated in the following leave year. The Court of Appeal then looked at the Working Time Directive and they said that it clearly entitles all workers to 4 weeks paid leave without workers having to request to carry this forward to another leave year if they're off sick. Mrs. Lana was therefore entitled to take her annual leave at another time when she wasn't sick, after the 2009 to 2010 leave year if necessary. However, given that Mrs. Lana never returned to work from sick leave, she lost her opportunity to be able to take this annual leave at a later date. So the court said that her only option was to carry her untaken holiday forward to the next leave year and to then receive a payment in lieu on termination instead. Although the court held that Mrs. Lana could directly enforce the Working Time Directive against the NHS because the NHS is a public body, this case is still significant for private sector employers as well. This is because the court confirmed that the Working Time Regulations 1998 could also be read and construed in accordance with the Working Time Directive. Therefore, the position would have been exactly the same had Mrs. Lana been employed in the private sector instead. So it now appears that workers who can't take their annual leave because of sickness don't have to request to carry this over into the next leave year to be able to receive a payment in lieu on termination of their employment. This case is significant then because it goes further than the previous EAT authority of Fraser and South West London St George's Mental Health Trust from earlier this year, which had previously suggested that carryover was permitted by the Working Time Regulations, but only where employees requested it. Although Lana now then appears to go further to allow carryover without employees needing to request this, the Court of Appeal only addressed the Fraser case in passing, finding that this Lana case could be distinguished from the Fraser case on the facts. So overall, employers in both the public and private sectors are now best advised to allow workers to carry over their accrued holiday if they have been on long-term sick leave and have not therefore had the opportunity to take that holiday. Watch this space though for more updates in this area. Next up is the proposals to charge fees in the employment tribunals. You might well be thinking that you're hearing things, but it is true that the government has announced controversial plans to introduce a two-stage fee charging structure in the employment tribunals and the employment appeal tribunal. These proposals are set to come into force as early as summer 2013. Let's look at the detail then. In the tribunal, claimants will be asked to pay an issue fee of between £150 and £250. This is just to submit their claim. This would then be followed by a hearing fee of between £230 and £950, which would be payable around 4 to 6 weeks in advance of any hearing. In the EAT, appellants will be required to pay £400 to issue an appeal and £1,200 to proceed to a full hearing. In the tribunals then, the variation in fees will depend on the type of claim. More straightforward claims like unpaid wages, redundancy payments and payments in lieu of notice will be categorised as level 1 claims and will attract a lower fee. All other claims, including probably the ones we all deal with more often, such as unfair dismissal, discrimination, equal pay and whistleblowing, will all be categorised as level 2 and will require the higher fee. Where there are multiple claimants, the number of claimants will also affect the level of fee, and not forgetting there will also be additional fees payable by both parties for making specific applications. Quite a bit to take in then, so I took the opportunity to ask Kate Edmondson, an associate in Addleshaw Goddard's employment group, for a few questions about the potential consequences of what these proposals might mean. Hi Kate, well this would seem to be good news for employers, is that the case?
I think so. I'd expect there to be less tribunal claims coming through and certainly less claims from claimants who are sort of trying it on essentially. That said, before we get a bit carried away with it all, I think claimants are likely to want to recover the fees that they've paid whilst dealing with settlement negotiations, so it may be that there's some discussion about that at that stage. Also, the proposal suggests that tribunals will be able to order that an unsuccessful party reimburse the fees paid by a successful party. So if an employer is unsuccessful, then they might end up reimbursing those fees at that stage.
Right, yeah, so they could still be on the hook. I suppose the other angle that's interesting is how does this leave employees who may have good claims and may not feel that they can afford to bring a claim?
There's certainly been some controversy around the proposals, particularly from employee groups who believe that it might affect, the proposals might affect access to justice. However, for claimants who aren't able to afford the fees, they'll have to provide proof of their financial eligibility, but provided that they can do that, the idea is that the government will be proposing to extend the current remission process, which takes place in the civil courts, and extend that to the employment tribunal system.
Oh, right.
I believe that the public consultation on remissions will be published in autumn this year, with a view to the fee proposals coming into force in September 2013, so I think we just have to watch this space.
Oh, thanks very much, Kate. Next up then is some welcome guidance recently issued by ACAS to help employers handle redundancy processes correctly for employees who are pregnant or on maternity leave. There's no new law in here, but this guide is very handy because it answers a number of common questions that can often crop up regarding employees who are pregnant or on maternity leave at the same time as a redundancy process. So it's well worth a read. You can access the ACAS guidance by clicking on the link below the screen. And finally today then, a 33-year-old footballer who used to play for League Two Gillingham Football Club has made British legal history by becoming the first black footballer to successfully bring a claim of racial victimisation against a professional football club. Mr McCammon was sacked by Gillingham last year and accused of misconduct, but the player told Ashford Employment Tribunal that he and other black players at the club had been treated differently to white players. Ashford Employment Tribunal found for Mr McCammon, confirming that he had been unfairly dismissed as a result of racial victimisation at the hands of Gillingham FC. So, in a year where racial tensions have already featured at the forefront of football in this country, There's perhaps no coincidence that this decision emerged while the world's spotlight was on London 2012. It will be interesting to see whether this decision sets a precedent for any other similar cases. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.